Hey, federal employees. So are those shutdown RIFs legal? Well, let's break it down. There is a case seeking a TRO going on. I've read all the major filings and want to give you an update on that. So this covers what you can call the shutdown RIFs. The same judge that blocked the RIFs earlier this year is handling this case, got assigned this case. And the bottom line up front is she moved a TRO hearing up to tomorrow at 10:30 a.m. Pacific time in San Francisco. So we'll likely hear more tomorrow. A TRO would freeze the RIF notices in place if she grants it. Here's what's going on in that case if you've not heard or want a refresher. So two unions, AFGE and AFSCME, have sued the Office of Management and Budget and the Office of Personnel Management over shutdown guidance that tells agencies they can use the shutdown to issue permanent layoff notices, RIFs, and that employees can be required to work during the shutdown to process those RIFs. The unions say that's illegal under the Antideficiency Act and the Administrative Procedure Act, and they're asking the court for an immediate order to stop it while the case is heard. So let's start with the basics. In a shutdown, really, there are two buckets of employees. You can break it down even more, but it's accepted employees who keep working but aren't paid until the funding resumes. Everybody else is usually considered furloughed and legally barred from working during the lapse. When funding returns, both groups are entitled to back pay. That's the historical practice, and it's baked into law. A RIF is different. A RIF is a permanent separation, downgrade to shrink or reorganize the workforce. By regulation, RIFs usually require 60 days written notice. Sometimes it can be lowered to 30. And there are complex rules about retention rights, veterans preference, bump and retreat, and potential reassignment to other position. RIFs are not the tool the government has used to manage shutdowns in the past. In fact, OPM's own shutdown materials say RIF rules don't apply to emergency shutdown furloughs because shutdown length is unknown and driven by Congress, not agency choice. So what changed here is the guidance. According to the complaint and TRO brief, OMB issued a lapse memo and OPM followed with updated guidance and special instructions telling agencies they may treat work necessary to administer the RIF process as accepted during the shutdown, meaning HR-related staff can work through the lapse to plan and push RIFs, and agencies can move from temporary furloughs to permanent layoffs even when the government is unfunded. The unions argue that this turns the shutdown framework on its head. Here are what I think are the core legal arguments that the unions are pressing. First, the Antideficiency Act is a stop work statute. It doesn't authorize new work unless the task is specifically accepted, like protecting life and property, or minimum steps to orderly suspend operations. Agencies can't do it during a lapse. The unions say RIF planning and processing does not fit any exception. Second, they argue that OMB and OPM exceeded their authority. Congress gave hiring and firing powers to agency heads within statutory limits. There's no statute that lets OMB or OPM order government-wide layoffs or convert shutdown furloughs into RIFs. Third, they say the guidance is arbitrary and capricious. It reverses long-standing practice without a reasoned explanation, conflicts with OPM's own shutdown guidance, and disregards reliance interests of the employees and the public. They're also raising an appropriations clause theory. If Congress hasn't funded the work, you can't spend money to run a RIF during a lapse. So what relief are they asking for? Well, they're looking for a temporary restraining order to pause any shutdown-based RIFs, including the behind-the-scenes processing, plus an order requiring the government to disclose what notices have gone out, the notice periods being used, and the scope of any planned RIFs. They also argue that any pause has to cover programs, positions, or activities that include their members because RIF retention rights are interdependent. You can't carve out just union members without affecting the whole RIF calculus. So where the case stands right now, well, the lawsuit was filed at the end of September, amended early October to add a long list of agency defendants, so any injunction will bind the agencies actually implementing layoffs. The unions filed their TRO papers on October 10th. On Friday, the court noted filings showing some agencies had begun issuing RIF notices that day. In response, the judge moved the TRO hearing up to October 15th, that's tomorrow at 10:30 a.m. in San Francisco, and ordered the government to file a supplemental declaration confirming, among other things, how long the notices are. So we'll probably hear more about this tomorrow, but that's the basics of what's going on. What do you guys think about this situation? Please double tap and support to help get this out and drop your thoughts below in the comments. Thank you everybody for your support. Take care and have a great day.